This is the ruling on sentence. I'll start with a brief background of the present content of court proceedings. On the 23rd of August 2024, the first petitioner approached this court via a notice of motion application and a certificate of urgency, alleging the abduction or arrest of the second to the fourth petitioners on the 19th of August 2024 by persons who had introduced themselves as police officers. They were then kept incommunicado in undisclosed locations after the incident. The court issued ex parte orders in the first instance as follows. 1. That pending the hearing and termination of this application inter partes, an order is hereby issued directing the respondents to immediately disclose the whereabouts of the second to the fourth petitioners to the first petitioner. That pending the application, the hearing and the termination of this application inter partes, an order is hereby issued directing the second respondents to immediately release or produce the second to fourth petitioners before any court of competent jurisdiction to make such orders as may be appropriate to uphold the rights and fundamental freedoms of the second to the fourth petitioners. 4. That the matter was then fixed for mention on Monday, the 26th of August 2024 at 10 a.m. to confirm compliance. During the virtual session held on 26th of August 2024, only the advocate for the petitioners, Ms. Omwenga, appeared. She informed the court that the orders made on 23rd of August 2024 were duly served, as was evidenced by the affidavit of service. However, there was neither appearance by any of the respondents or responses to the habeas corpus application. There had been no compliance with the orders either. That necessitated the court to vary its orders, in which it directed that, pending the institution of the changes, if any, the court now directs the unconditional release of the second to fourth petitioners by the first respondent. Number 2, that physical service of the order be effected by close of business that day. And number 3, that summons do issue to the first respondent to appear in court on the next mention to explain why the habeas corpus issued by the court were not complied with. The matter was fixed for the 9th of September 2024. On the morning of the 9th of September 2024, the Attorney General, the DPP, and the Director of Public and the Director of National Intelligence Service, the Inspector General of Police, and the Director of Criminal Investigations appeared through counsel. None of them had filed a response to the application, and the orders of the 23rd of August are not being complied with. The Inspector General of Police, who the court had summoned, did not turn up either. The court postponed the matter to 3 p.m. for physical attendance of the Inspector General to explain why the habeas corpus orders are not being adhered to. The afternoon came and passed. The Inspector General of Police did not attend. The court was informed that he was out of office on official business, with the nature of business being revealed to be a workshop he was attending in Mombasa on budgeting that particular morning. In the afternoon, the court was told that he was engaged in security operational duties in coastal region. The matter was rescheduled to 5th of September 2024 at 10 a.m. as the court was keen to establish why the habeas corpus orders could not be executed in respect to the production before the court or the release of the second to fourth petitioners. Ms. Mwangi, who appeared for the Inspector General, explained as follows when pressed to explain the apparent persistent disregard of the court summons by the Inspector General of Police. The Inspector General of Police has not said he is not coming. He is requesting for another date because it is our position that the second to fourth petitioners are not with the police. The Inspector General of Police is requesting another date to appear because we had thought his officers would explain. The Inspector General is requesting another date to appear in court, and after holding some brief consultations, Ms. Mwangi saying the Inspector General of Police will come on Monday, 9th of September 2024. The officers of Inspector General of Police are here and have confirmed his availability on Monday, considering his work and duties, end of quote. The court, after this brief session, fixed the matter to 3 p.m. on the same day. Despite the court convening, the Inspector General did not show up. The court finally and reluctantly agreed to give the final opportunity to the Inspector General of Police to attend court, coinciding with the date that the counsel for the Inspector General indicated he would be available. This was after she had made some brief consultations. The date was Monday, the 9th of September 2024. On that day, the court distressingly wrote, and I quote, "The stream of reasons and excuses by the Inspector General of Police are definitely bound to run out. To proceed at this juncture and history make a finding of contempt of court may be seen as premature in a grave matter of contempt of court, which is a form of criminal sanction, being an offense against the administration of justice. Our Constitution requires a high threshold of criminal matters. Reluctantly, the reasons for non-attendance today must be considered. It is thus necessary that I postpone these proceedings to Monday, the 9th of September 2024. The Inspector General, having earlier indicated his availability on this particular day, should have no further excuse but to comply and attend the court physically at 10 a.m. so that the court can put this matter to an end." Due to the persistent non-compliance with both the court summons as well as failure to comply with the orders of 23rd of August 2024, the court opined that it was a case of contemptuous conduct that the Inspector General needed to punch even as he set the date for the 9th of September 2024. That date came and passed through. The Inspector General did not turn up, but he made last-minute attempt and sent his Deputy Inspector General in charge of Kenya Police to appear on his behalf. The court rejected the arrangement, noting that the open defiance of the court summons had metamorphosed to contemptuous conduct and was now a personal matter that had to be directly and specifically addressed by the person summoned. Following the failure to attend court or comply with the order of 23rd of August 2023, the court entered a finding of guilty for contempt of court against the Acting Inspector General of Police on the 9th of September 2024 and defined the sentence to Friday, the 13th of September 2024. The sentence. As part of considering the appropriate sentence, I want to look at this matter from a constitutional perspective. The preamble to the Constitution reflects the commitment of the people of Kenya to attain a number of aspirations. One of them is statement number 6 of the preamble, which states as follows: recognizing the aspirations of all Kenyans for a government based on essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The Constitution under Article 2, Sub-Article 1, proclaims itself as the supreme law of the land that binds all persons and all state organs. Article 3 obligates every person to respect, uphold, and defend the Constitution. It matters not whether they are mighty or low. The Constitution further proceeds to specify the national values and principles of national governance that bind all state organs and all persons whenever they make and implement public policy decisions, enact laws, and interpret. Among those values and principles are that contained in Article 10(2)(b), which as human rights, the rule of law, among others, whereas Article 10(2)(c) as the principle of accountability. In matters of national security, Article 238 provides that the principles we shall apply and include the following: that national security is subject to the authority of the Constitution, and the national security shall be pursued in compliance with the law and with utmost respect for the rule of law, democracy, human rights, and fundamental freedoms. The rule of law principle is thus a common thread that the Constitution every demands in almost every function to ensure that every person is held accountable to the law. It ensures the equality of all before the law and prevents arbitrariness. The task of the court is to ensure there is a fair balance by applying the law when disputes arise either between the state and its citizens, or between citizens themselves, or between state organs or agencies. Neither a state organ or its officers or individual is above the reach of the law, as the Constitution in Article 2, Sub-Article 1 declares. The power of the court to adjudicate disputes according to the law is a delegation by the people pursuant to Article 159, which states that judicial authority is derived from the people and vested in and shall be exercised by courts and tribunals established by under the Constitution. The power is exercised subject only to the Constitution and the law, and is not subject to the control or direction of any person or authority by Article 60. The following excerpt from the South African Constitutional Court in the case of Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including organs of state versus Zuma and others, sums up the position of court orders in a constitutional democracy. The court held, orders and decisions issued by a court bind all persons to whom and organs of state to which they apply, and no person or organ of the state may interfere in any manner with the function of the courts. It follows from this that disobedience towards court orders or decisions risks rendering our courts impotent and judicial authority a mere mockery. The effectiveness of court orders or decisions is substantially determined by assurance that they will be enforced by all and sundry, including organs of state. In doing so, courts are not only giving effect to the rights of the successful litigant, but also, and more importantly, by acting as guardians of the Constitution, asserting their authority in public interest. End of quote. In the civil application, Dr. Fred Matiang'i, the Cabinet Secretary, Minister of Interior and Coordination of National Government versus Miguna and 4 others, the Court of Appeal, affirming the power to punish for contempt, held as follows: when courts issue orders, they do so not as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cathedra are compulsive, peremptory, and expressly binding. It is not for any party, be he high or low, weak or mighty, and quite regardless of his status or standing in the society, to decide whether or not to obey, to choose which to obey and which to ignore, or to negotiate the manner of its compliance. This court, as must all courts, will deal firmly and decisively with any party who deigns to disobey court orders, and will do so only to preserve its own authority and the dignity, but most to ensure and demonstrate that the constitutional edicts of equality under the law and the upholding of the rule of law are not mere platitudes but present realities. End of quote. The court entered a finding of guilty. This court entered a finding of guilty on the 9th of September 2024 after all efforts afforded to the contemner to purge the content were ignored. This was to ensure its authority and dignity, which it is exercised on behalf of the public, does not get annihilated, leading to a situation of impunity and anarchy. The Supreme Court, in Githiga and 5 others versus Geriko Tea Factory Company Limited, acknowledged that courts have inherent power to punish for contempt to vindicate their authority, besides pinpointing the source of authority of Kenyan courts to punish for contempt after declaration of unconstitutionality of the Contempt of Act 2016. The court stated, and I quote, "Courts possess the inherent power to enforce compliance with their lawful orders through sanctions imposed through contempt of court. We note that the Contempt of Court Act, having been declared unconstitutional in Kenya, Human Rights Commission versus Attorney General and another, 2018 EKLR, on November 9, 2018, the instructive provision remains Section 5, Subsection 1 of the Judicature Act, which grants the High Court and the Court of Appeal the power to punish for contempt. It provides the High Court and the Court of Appeal shall have the same power to punish for contempt of court as for the time being possessed by High Court of Justice in England, and that power shall extend to upholding the authority and the dignity of subordinate courts." End of quote. Today, this court is required to pass sentence for contempt of court. The principles to be considered in determining an effective sentence in a contempt of court matter were considered by the South African Constitutional Court in Jacob Zuma case, where the court discussed the coercive versus punitive order and explained the difference between the two approaches as follows. There is a distinction between coercive and punitive orders, which differences are marked and important. A coercive order gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is made primarily to ensure the effectiveness of the original order by bringing about compliance. A final characteristic is that it only incidentally vindicates the authority of the court that has been disobeyed. Conversely, the following are the characteristics of a punitive order. A sentence of imprisonment cannot be avoided by any action on the part of the respondent to comply with the original order. The sentence is unsuspended. It is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to assert the authority and the dignity of the court to set an example to others." End of quote. The court then went ahead and found that the conduct of the contemner, Mr. Zuma, and made it undesirable to benefit from coercive order, reasoning as follows. A coercive order would be both futile and inappropriate in these circumstances. Coercive committal through a suspended sentence uses threat of imprisonment to compel compliance. Yet, it is incontrovertible that Mr. Zuma has no intention of attending the commission, having repeatedly reiterated that he would rather be committed to imprisonment than cooperate with the commission or comply with the order of this court. Accordingly, a suspended sentence, being a coercive order, would yield nothing. End of quote. The contemner, in this case, was accorded every opportunity to purge the contempt to the extent that attending a workshop in Mombasa was more important than obeying a court summons intended to seek an explanation on the whereabouts of the second to that petitioners, last seen on the 19th of August 2024, the date of alleged abduction. Nevertheless, I took note that on the last date, the contemner attempted to bring in his deputy to explain the position with regard to the summons. The deliberate defiance of court orders brings impunity, particularly when it is done by those entrusted with public power, as it is inconsistent with the purposes and the objects of the Constitution. In passing this sentence, I am conscious that it is directed to the highest ranked police officer in this country. He is still in office. That might pose a challenge in the enforcement of the order, since in police service, seniority is highly regarded. That, however, cannot deter me from pursuing and standing firm in the defense of the aspirations of Kenyan people who desired at the time of enacting this constitution to have a country that is governed by adherence to the rule of law. Part of the oath of office that I took as a judge states as follows: I will at all times, and to the best of my knowledge and ability, protect, administer, and defend this constitution with a view to upholding the dignity and the respect for the judiciary and the judicial system of Kenya. End of quote. The constitution of this country is supreme, and Article 2.1 reiterates that by stating that it binds all persons and all state organs. No man or state organ or authority is above the Constitution. The Constitution command through this court is that I uphold the rule of law by protecting the integrity of the judicial system. The significance of this sentence today is to vindicate the cherished principle of the rule of law in our constitutional democracy by restoring the dignity and the authority of this court in public interest. Borrowing from the South African Constitutional Division, the contemner shall serve sentence as follows. The contemner, Mr. Gilbert Masengeli, is sentenced to 6 months imprisonment. Mr. Masengeli is ordered to submit himself to the Commissioner General of Kenya Prisons to ensure that he is to be committed to a prison facility to commence serving sentence of the imprisonment imposed. In the event that he does not submit himself to the Commissioner General of Prison Service as ordered, the Cabinet Secretary for the National Interior must take all steps that are necessary and permissible in law to ensure Mr. Gilbert Masengeli is committed to prison to commence serving the sentence imposed on him.